that paperwork, if you go and close a pre-series A deal with a new round investor, how will you negotiate your terms? For example, that is where private equity players want to invest money in you, right?
Yes.
Right. So that you can.
So first of all, thank you, Vivek sir, for uh, being on the podcast. It's pleasure hosting you. For an audience, I'll just brief a bit about you. So Vivek sir has been involved in transactions that is more than 4,000 crores, $200 million crores. He is a lawyer by profession. He has been advising both funds, startups as well at different stages across his work span. And currently he is with Fox, Mandal and Partner Associates, basically having a partner position. So yeah, uh, thank you for coming on the podcast and looking forward hosting to you.
Thank you, Himanshu, for having me over, and I look forward to a wonderful learning interactive session between you and me. Both of us learn, and our audiences also learn something and take something back.
100%. So, sir, basically, this question is out of my curiosity, right? Since you have been working with the startups at different stages, whether it's a fundraising journey or it's in general sense also advising them, right? So, when we started our first company called Started Up, we didn't knew anything about this. We didn't had any lawyers and all of that part. And later on at the funding stage, when we were in raising an angel round and that, so we tend to thought that hey, for these clauses and everything there should be some kind of a legal person to advise us. And fortunately for our, like for us, angel round who was putting in the money was a lawyer, so we were fortunate in that sense. But in a general, startups do not know about when to have a lawyer. Like initial stages pe though it's fine ki they are starting a company, they cannot board an extra expense, but then when to have a lawyer in the process of startup.
Okay, to answer this, you see, startup journey, as you know, you have been at the forefront, and dealing with a lot of founders as well as investors right now through your venture. It has evolved over last 10 years. So back there, if I go back to year 2013, maybe 2014 and 15, in fact, just the startup evolution had just started in India. Not so much. There were very good companies who had done well, like Naukri.com, etc. Those were also startups at one point in time. Even Reliance is also calling themselves a startup. But we'll skip a couple of these companies because they are very mature companies. Started at a different point in time when there was no term as such startup in the in Indian commercial or Indian ecosystem as far as jargon is concerned. Now, in 2015 and 16, most of the founders would not care about having a legal professional by their side, maybe definitely not in the seed round, and at times not until even in a pre-series A round. Many of them were there, but trend has changed. You see what happens when there has been a lot of traction as far as Indian commerce is concerned. Okay, there are a lot more transactions today, a lot more transactions post COVID. In COVID, you would know there were a lot more transactions multiplied 3x and 4x that point in time. So with more transactions comes more complexity and more disputes. Now, the founders, we deal with many founders who come to us, let's say at Series A or a pre-Series A stage, and they have already taken a couple of rounds of seed series financing from good investors, institutional investors, and good individual personalities also. Now, you look at their paperwork, that their paperwork is very bare. There are no protections in favor of the founder. Now, with that paperwork, if you go and close a pre-series A deal with a new round investor, how will you negotiate your terms? For example, in your initial paperwork, you had no indemnity liability limitation in favor of founders, which is a very key point. Okay, you had unlimited amount of indemnity for unlimited number of years. You had no personal assets carve out, like your house could be sold, etc. You had no carve outs because you wanted to close the deal. You wanted money to hit your bank account, right? That's the thing, right? Money should come as fast as possible. But when you go to a pre-series A for a larger round or a series A and onwards, the investment amounts are larger, your liability is also larger. Now tomorrow you cannot, it is very difficult to actually negotiate negotiate a pre-series A or series A round saying that now I'm taking a larger investment, company has a legacy, because at the seed round company is maybe 2-year-old, 3-year-old or 4-year-old company, but at series A round, for example, company is 5, 6, 7-year-old. A lot of things have come in place, a lot of things have established which were not there at the time of initial round of funding. Now you go to investor and you want to negotiate a term sheet with him saying that my indemnity liability vis-a-vis you is only up to the investment amount you are putting in my company and not beyond that. And I also want a personal asset liability carve out that you mera ghar baar nahi bechoge, right? Now the investor comes and will straight away tell you, why didn't you negotiate this with your previous round investors? I am giving you more money at a higher valuation, and you are giving me stricter terms of investments. While your earlier investors have unlimited liabilities for unlimited amount of period, I am paying you more at a higher valuation, and you are telling me that I limit my liability to the extent of investment amount I am paying. How do you actually negotiate that? That puts the founder and his team in a difficult scenario. You see, the idea of a startup is to become a mature company. And as the company becomes mature, so initially you are a startup founder, you're holding, let's say, 90% of your company, 10% आपने seed round में दे दिया, for example. While you're growing, your equity in your own company is going to get diluted. So there may be a time when you are at Series C or Series D level, you founders, all together of you founders are at 38% or 42%. You are in minority actually if you see that,
Yeah,
but you still
yeah.
continue as a single largest shareholder. But if you see overall cap table, you are in minority. But that is the success of growth of startup. Actually, you want to dilute cap table, diversify your cap table. You want to go in minority, because more investors pump in money in your company, you will automatically go in minority. So coming back to the question, at what stage one should hire a legal professional or be in consultation with legal professional? I say right after incorporation, because you are setting up a company to grow a company. You want a round of funding. So what happens when you are doing a round of funding? There are certain checks you have to do. Better managed companies which are good in corporate governance right from the starts have higher chances to secure a good institutional investment as opposed to other companies. So XYZ investors, there are lot of there are individuals who are ready to pump in 4 crores or 5 crores in a company. But what do you want? You don't want that 4 crores or 5 crores. You maybe want only 5 crores from an institutional investors like STFC Bank. You want only 5 crores, even if they give you lesser amount, but you want those kind of people on your cap table, because that adds a brand value to your cap table. That is what you want. Raising money is not the question. Raising money from the right sources which can help you escalate your company to a level you want to is the proposition actually. And that is where you see, since we have been talking, there have been a lot of traction in startup commerce, startup transactions, etc. You see lot of founder disputes are also coming into picture. So it is very essential that right after incorporation, all the founders, all of you, irrespective of anything, you have a good robust founders agreement in place. So tomorrow, if while you are looking to scale up your company, looking for investment, entering into business contracts, etc., and one of the founder does a fraud, for example a financial fraud, and you don't have a founders agreement in place, he still continues to be shareholder in his company. You cannot compel him to sell his shares to another founders, right? But you don't want him to continue. Correct. A founder, for example, is competing indirectly with the company. What do you do then?
Mm.
For all these metrics, and there are many examples like these, you need to have a robust framework, something which is called founders agreement. You can name it whatever you want to, but these basic parameters should be agreed as early as possible between the founders, so that founders also know this is the rule of the game. I cannot just vanish away at any point in time. I just cannot start competing with my own company, right? Because it puts the other founders in question that point in time. And then you have litigations, etc. Your company is gone. If you have litigations before in first 5 years in relation to shareholding dispute, your company is basically gone in the eyes of institutional investors. You may have to form another company doing some other business, right? So my answer after all these discussions we are having is that even if you don't engage a legal professional right after incorporation, just be in consultation of legal professional. Because what happens, the kind of work we do, like I also do, this corporate lawyering, corporate advocacy profession is, I tell you, 70% commerce and only 25 to 30% law. So we end up advising our client on commercial indicators, commercial parameters, commercial enforcement of certain, the attributes of certain framework that they have agreed, more than the legal part actually. This is how it is actually. And we tend to deal with a lot more other clients, so we are also aware of the market practice. You see, market practice is at time also very, very, very important, because you cannot be investing all your time in finding out answers at all point in time and doing research and asking 10 people. So you need to be in consultation with some person who has been doing like deals with some other companies, and he knows what are the permutation combination of shareholders right or founders right, inter se founders right, for example. What are the important indicators at seed round, for example. So let me quote you, for example, seed round exit is not very important, angel round for exit is not important, company is just formed, you're just putting in some amount of money, exit is not important. But when you go to pre-series A onwards, exit is very important.
Mm.
That is where private equity players want to invest money in you, right?
Yes.
Right. So that you can provide them with an exit. That is why venture capitalists are also investing money in you, so that you can provide with them an exit as per their calculation of investment amount for internal rate of return, whatever metrics you have agreed. So success of the company, from the objective of investor, is that investor gets an exit from the company
Mm.
actually at a higher valuation than they have invested. Otherwise their investment is going to go bonkers. For example, look at Byju's. It was once, couple of years back, 3 years back, it was valued, post money valuation, some enterprise valuation, sorry, was somewhere 15 billion USD.
Even
Now it is $3
higher,
billion.
like world's largest highly valued tech company.
Yeah, now it is 2.53 billion. So look, there is a massive write up of 80% of investments,
I think
right?
even one bank termed it as zero, in terms of
Maybe.
valuation.
Exactly. There are we are just taking that
Yeah.
example. There may be a lot of forces at play that we don't know, that are not available in public information, and it doesn't worry us, and it's not called, case of our concern at all. But just just summing it up, even if you don't engage a lawyer, be in consultation of lawyer, because consultation of lawyer will help you to harmonize and align your company's business objectives in a proper way, so that your company is more sellable, looks is better placed than other companies in the same
Mm.
business. So for example, I tell you, and this also helps you when you are looking to take funding, and the funding side, investor side is doing legal, commercial and technical accounting due diligence. They will, if you have business with several vendors, suppliers or customers, etc., and you don't have robust contract with them, they will tell you that they will only put in money in your company when you have robust contracts with them, what is typically in our terms, transactional term, we call condition precedents. So higher the number of condition precedent, the more time deal will take to close, you see. So if I'm not doing something which I should have done now, and later on 2 years down the line, investor is doing the due diligence and telling me you should have done this earlier, you have no contracts in place, so tomorrow somebody vanishes with your money, doesn't pay you for your service, what is the recourse you have? You'll have to go to dispute, and then there is no contract, dispute will take more time. I don't know what will be the conclusion of the dispute, but it will elongate the time actually. So instead of investor later point in time pointing you out of certain basic elements, you should you know cover them while you are running the company. This also helps you to get better valuation for your company. So I tell you, for example, if your company in such a business, you required XYZ licenses, for example,
Mm.
you took couple of licenses, you did not take the third licenses, maybe you were not aware, right? Because legal, there are a lot of legal changes at
Mm.
times, or maybe some filings you have done was required to be done, you had not done it. Tomorrow investor does a due diligence, he straight away finds out that, right?
Mm.
He tells you the implication, the monetary implication of this violation is XYZ amount. I will deduct that XYZ amount, okay, from the total valuation I want to pay to you, my investment amount. You lose that in this scenario, you lose that amount upfront. Or investor will tell you, I will take a specific indemnity from you if at all there are notices come tomorrow on this count. Notices may come sooner or later, you don't know, right?
Mm. Mm.
But you're living with that, double-edged sword till the time notices come in the second scenario. So it is important right after incorporation, while you are finalizing business relationship, etc., related party transactions, etc., formally document it, so that there is a fair play. It should not be one-sided contracts, etc. Consult a lawyer. Lawyer helps you to prepare
Yes.
a ground for you, so that when the investment happens, rubber can hit the road for you, and that's what you want actually.
Yes. Yes. 100%. But since we are talking about early stage startup, and you rightly put up, like you do not need to hire a lawyer, you can be in consultation with it, right? So, seeing considering like it's a very early stage startup, it just got started. What do you think the average cost of a lawyer per month on terms of consultation is?
Look, it depends from lawyer to lawyer actually.
In
You see,
generic sense, like it can start if you have to give a range, like from this to this, that can be.
no, it depends. It depends. I tell you how it depends. It also depends on the experience of
Hmm.
that particular lawyer to deal in such kind of work. Actually, if a lawyer does not have experience to deal in such kind of work, his hours and his time on that assignment will be more. So he
Yes.
will bill more, right? Okay. But if a lawyer who has done more of the nature of those transactions, his time on the assignment will be less, and he will also add experience. So from the legal perspective, is always about giving your time and experience to the client. That's what we bill for. So you see, for example, a founders agreement is there, so there can be lawyer who would say I will charge 80,000, but there can be lawyer who has lot more experience and will tell you, okay, I'll charge 1.5 lakh, but I'll tell you all the permutation and combinations
Hmm.
available, market practices, so that you founders can interest decide what can be done. You see,
Hmm.
then you can take a call, because you need a legal advisor, legal come commercial advisor, to tell you these are 10 things which has been happening in the market.
Hmm.
You ponder over it, discuss intensely. I am there to guide you. You choose which one is best for you.
Hmm.
For example, there are certain founders agreement, they also have performance metrics actually.
Hmm.
They say there's a person who is a CTO, there is a person who is doing the sales thing, there is a person doing something else, and they have inter se rights and responsibility. They saying that if person X will bring this much amount of business to the company over the period of 3 years. If he doesn't bring so, his equity will go down. His equity will get distributed to other founders who have done so, right? So different founders agreements have different permutation and combinations. Certain things are common. For example, if there is a fraud, if there is a posh case, sexual harassment, etc., you don't want to continue with that founder, because you have to protect the brand value of your
Yes.
company also. So at that point in time, the other founders can buy out the stake of the defaulting founder at a
Hmm.
deep discount that point in time.
Hmm.
So out of 10 elements, if I say
Hmm.
5 6 elements are standard, but for other 5 or 6 elements, you need somebody who has experience and can guide you and tell you, okay, this is practical, this is not practical.
Hmm.
Some people in the market are actually doing like this. You see, so that is where, so the fees could be, it can be in a range. As I said, it can be, let's say, 80,000 to 1.5 lakh, for example. So it can be 0 to 2x actually that way.
Gotcha, gotcha. But you also said that it can also lead to the house can be sold. You mentioned in that. So if the terms are not right, right. So what are these? What are possibly you can say like uh, maybe two or three things that can go wrong if the things are not taken up correctly in terms of legal perspectives.
So what happens? I tell you, I come across this scenario very often.
Hmm.
Actually, I tell you, okay, okay. More the number of transactions, more so we come across these
Hmm.
scenarios. So especially what happens, at times, mostly founders sign the term sheet in haste
Hmm.
because of the pressure put in by the investor.
Ah,
You see, you got a term sheet from a good investor actually, and he will tell you, okay, sign it as early as possible. Look, we have other avenues to also invest. So there is some kind of indirect pressure on you to deliver as early as possible. Maybe he can tell you, okay, I will send you this today evening. If you can share it in next 2 3 hours
hmm.
after I send you, right? Or maybe next morning. So you don't have that much of time actually, you see. But I tell you, based on my experience,
Hmm.
all the stakeholders, including the investors, it's just like selling your thing actually. You see,
Hmm.
whether to negotiate for your rights or certain elements in, let's say, for a document like a term sheet, it is also up to the founder and the promoter to say to the investor, yes, we will review. We have a legal counsel, who regularly works with us. He will also have a look at the term sheet. While we will work on expedited timelines, we want to complete this transaction as early as possible, but we need to run this through him. You see, Because what happens once you have signed the term sheet, a one-sided term sheet, a 2-3 pager term sheet, which has no protection, market acceptable protection whatsoever for the founder and promoter. Now, while discussing, negotiating the main transaction document, shareholders agreement, if you raise those protection points, that point in time, straight away investor will tell you, you are killing the time. Why didn't you raise these the points at the time of term sheet? Now we are mentally prepared. We have got the funds already in our bank account, and we want to put in money in your company. So this is how it happens actually. So this is indirect pressure, and a lot of promoters and founders get into pressure. But if you have to play long term game, and that's what the purpose is. Purpose is not to take a seed round financing. Purpose is get to series D and series E, or eventually get to an IPO, create a name for yourself, brand, create a brand for yourself, like companies like Zomato have done it, Swiggy have done it, many other companies in D2C brand, fintech companies have done it. That's the game, right? You have to be a long term player. You can be a long term player as a founder, as long as you have certain certainty as to your liabilities, ring fenced liabilities. Okay, and you have flexibility of operations, because eventually it is the founder which is going to give the return to the investors. Investor don't give returns to the founders, right? Founder is controlling the company, or if not controlling the company, let's say at series D or series E, for example, founder is running and managing the company, right? It is basically on the performance of the founders, other stakeholders of the company's benefit, right?
Yeah.
And not vice versa, not maybe vice versa, but not entirely vice versa, right? So if you have a documentation, if you have a rights or metrics or framework where promoters are totally pressed, for example, they may not feel that flexibility to operate the company actually. So they may be disinterested in the company after they have made some money, right? After you have created some valuation, your founder promoter can feel like, okay, there is too much liability on me. I'm not able to do anything without the consent of investors, and investors are either not turning up or not giving their consent. How am I going to run the operations of the company? So I give you one example, a very pertinent example on this count. We'll also take up once we go to other questions and other reference pointers we have with us. For example, there is a reserve matter right of affirmative voting rights common in all shareholders agreement in relation to venture capital as well as private equity. It says these are the 10 items, 10, 20, 30, whatever those items are. You cannot pass a resolution on those items without taking prior approval of the investor.
100.
Okay. So the resolution is contingent on the approval of investor. So tomorrow when I call a meeting, okay, and the quorum says the presence of nominee director of investor is a compulsory, is required.
Yes.
So I call a meeting, all of us founder turn up in the meeting, couple of other people also turn up in the meeting, but investor nominee does not come. What will I have? I have to reschedule the meeting, adjourn the meeting. I adjourn the meeting again. Days after 7 days, 15 days, same place, whatever that is. Again, the investor nominee does not come. And mind you, all the matters in the affirmative voting rights list are important matters, are important contracts,
Yeah.
are important actions of the company. What do you do then? You are not able to resolve on those matters. You are actually killing your company, right? You're killing the company for all the stakeholders. To ward off this, what we suggest our founder clients, yes, we agree to create a fair play metrics in the documentation and framework. Yes, we agree. Investors have put in money, so they are allowed for protective rights, right? Their nominee should be present in the meeting. So what we say, for example, nominee should be present in the first meeting. If nominee is not present in the first meeting, nominee again has the option to be present in the second meeting, right? After a gap of 15 days, for example, or 7 days, whatever that is. But the nominee is also not present in the second adjourned meeting, or maybe I also give a leverage of a third adjourned meeting, for example, depends on negotiation. Even if he is not present in that point in time, then the promoters, the directors present that point in time should be able to resolve on all matters, including the reserve matter list, right? Otherwise, a nominee director does not turn up for 6 months. You keep on calling
Yeah.
meetings. Company is dying, right?
तो डिसीजन तो कभी होगा ही नहीं.
Exactly, how do you take decisions in that scenarios? So that is why it is advisable. So all those things, when we are negotiating the term sheet, all those things go in very limited words in the term sheet, not so much in the various paragraphs, as they will be dealt with in the transaction document that later point in time. But all those things should be indicated in the term sheet itself, so that there are no surprises at the time of negotiating transaction document, and everything is efficient, time wise, and alignment wise also. And that is where the first step involving the lawyer, as I said, post incorporation, it is helpful to involve a lawyer, and definitely so prior at the time of doing the term sheet, because term sheet is not done right, it is very difficult to negotiate a lot of pointers later on,
Yeah.
at the time of transaction document, because investor will straight away tell you, okay, you're killing the time. I wanted to do this deal in 10 days. Since you are negotiating, it may take 90 days, right?
Yes.
So, you are killing the time. Oh, okay, I don't want to do. I mean, they will do the deal. Look, finding good companies are also very difficult. Okay,
Hmm.
as much as finding good investor, it cuts. The road opens both ways and it cuts both ways actually. You see, but then the negotiation is an art actually.
Hmm.
How much you allow the other side to negotiate, how much pressure you put on the indirect mental pressure on the other side,
Yeah.
and you want to see how do they react. At times, as an investor, I am also prepared. Okay, if he asks me again and again on the same point, I will give up, because
Hmm.
I also think practically.
Hmm.
Okay, but you don't get until you ask.
Hmm. True.
And how do you ask? You need a legal advisor in your favor who looks at term sheet, says these are the 30 points in the term sheet. Out of these 30 points, 10 points are must have points, 20 points are good to have points. Let's raise all the points and let's try to get as much as must have points either in the term sheet. Matlab term sheet we can only mention something to the extent possible. Definitely in the transaction document, trade good to have points for the must to have points.
Hmm.
And that is what the art of actually the negotiation is. So a lawyer, from legal perspective, from advisory perspective also, we also have to be clear, depending on the deal, size of the deal and the participants, reading the room, etc. We have to see what are the must have for these deals. These are the 5 items which are must have for me, and these are 20 items which are good to have. I want to fight for must have.
Hmm.
And while fighting for must have, negotiating for must have items, if I get 5 6 good to have points, it's cherry on the top, right?
Hmm. But again, coming to that thing, since that's the thing. So you said that कि like absolutely rightly put up कि decision में delay हो जाएगा अगर investor show up नहीं करता, right? This is the second thing I would consider कि जो अगर fundraising clause में सही से नहीं you have taken the lawyer, that can go wrong. So one was the sale of house, second is the no decision in the company that will go. So what do you think the third could can happen, right, in that thing?
No, I tell you, look, there are various points which are important as
Hmm.
far as deal making are concerned. So it is difficult to actually say these are top three or these are top five.
Okay.
Actually, it depends. It depends on the size of investment. I tell you,
Hmm.
depends on the stage of investment, whether it is Series C or Series B,
Hmm.
Series A.
Yeah.
It's all
Understood.
metrics for example. So you see, most important point for me, irrespective of the scale of the deal, or
Hmm.
nature of the deal, C2, Series C, etc., is indemnity actually. So as a founder, what do I want? There are certain parameters in indemnity. I tell you, my indemnity's total liability should not be more than the amount you have given me. That is fair. It cannot be unlimited. Yes, I have breached something. I have breached a representation warranty I have given to you. Yes, you can. You have an indemnity claim against me. I'll give you indemnity, but that indemnity should be limited to the total amount of investment you have given to me.
Hmm.
Very fair, actually. Cannot be unlimited. There should be a personal asset carve out, very specifically mentioned in the agreement.
Yes.
Okay, when I say personal asset carve out, your personal properties should not be, disposed of for the purposes of fulfilling that indemnity. What can be done alternatively is that in case you are not able to pay the indemnity from your pocket, for example, there are permutation combinations in that also.
Hmm.
What you can do, you can choose to divest your shareholding in that company, and
Hmm.
whatever proceeds you received from the sale of shareholding, you can give it to the other side as an
Yes.
indemnity payment, right?
Basically, secondary is kind of कर लो, right?
You can do secondary, right? Okay, secondary is also a personal property, but it is different kind of a
Hmm.
personal property as
Hmm.
opposed to your ghar-bar and everything.
Yes.
Those are different. Okay, now when I'm looking at indemnity, I'm also looking at, like we have covered the overall liability aspect, I'm also looking at certain threshold within my overall liability. These are called de minimis tipping basket. So de minimis says, if the de minimis sets an amount of indemnity which, if crossed, becomes claimable. So I give you an example. You have done a 10 crore deal, for example,
Hmm.
and you have said my de minimis is 1 lakh. That means any loss which is below 1 lakh is not claimable, because 1 lakh is very small amount,
Hmm.
right? If you run entire indemnity process, include your lawyers, etc., investor will include its lawyer, etc., right? You will discuss, etc. The cost will be more than 1 lakh.
Hmm.
be more than indemnity. And that is where de minimis is important. You said I put in de minimis of 1 lakh and 5 lakh. Below this, it is not claimable. Once an amount crosses the de minimis, you have tipping basket. You say once every 1 lakh rupee or more than 1 lakh rupee aggregate to, let's say, 5 lakh rupee, that is the point in time I'll indemnify. So it helps, the job of the promoters and companies definitely not giving indemnity at all point in time. You wait for certain time period, you see that indemnity has become of decent sizable amount agreed between you, and then you indemnify it if there is a breach, if parties have agreed actually. You see, that is important. The third parameter is having sunset period actually. For how long you're giving these indemnity claims. You see, now the representations and warranties, basically representations and warranties are a statement of facts, okay, in relation to the companies which are given by company and the founders. Basically saying companies duly incorporated, companies have all the business contracts duly stamped, company has complied with all labor legislations, has all licenses, etc. Whatever that is, okay. And if there is a breach of that, and if there is a loss to the investor, then it becomes an indemnity claimable, depending on what de minimis, etc. you agree. Now, for how long will you give investor right to claim indemnity? So typically, representations and warranties are divided into three buckets. One is business warranties, one is fundamental warranties, and one is tax warranties. So fundamental warranties, to start with fundamental warranties, those are those warranties that goes to the root of transaction. Okay, if that warranty is false, then the entire transaction is at stake actually. So for example, I say my company is duly incorporated, etc., etc., and if there is a breach of that, for example, it goes to the root of transaction. I have no company or whatever, right? Or if I say no insolvency proceedings against me, right, then it goes to the root of transaction, because insolvency everything can be sold, right? Or if I say promoters title to shares are not encumbered, but later when you find out they have already encumbered to a third party, that affects the transaction. If you knew it earlier, you will not do the transaction. These are fundamental. So one exception has been created for fundamental warranty. Again, this is a market practice, depends on parties to parties. That fundamental, as far as breach of fundamental warranties are concerned, there are no limitations, like limitations of overall investment we discussed. It is not applicable to fundamental warranties, and breach of fundamental warranties can be claimable any point in time by the investor, right? Whenever he suffers a loss. So there is no sunset period as far as fundamental warranty is concerned. But when it comes to business warranties, typically parties agree, you know. So I am giving, representation warranties as of today's date. That is a closing date when I'm taking funding from you. Now, larger the time passes, the chances of my warranties being in breach is, lesser. Lesser. It is inversely proportional. You see, so it cannot be. It shouldn't be a case that, if I've given you a warranty, nothing has happened in 5 years, and at the end of 10th year, 15th year, somebody will say and do a claim. It doesn't
Yeah.
happen actually. It is inversely proportional. So typically, people agree as far as sunset period for business warranties are typically 3 to 5 years. In a mature deal, it is around 18 months to 30 months also, because the logic is investor requires 2 audit cycles to get to know company more actually. So it can be anywhere between 18 months to 5 years, depending on the negotiation and the kind of warranties. Different warranties can also have different sunset period at times. Those are complicated deals, but not at the startup or VC level. People don't go into, dissecting each warranty, saying environmental warranties for this many years, this kind of warranty for this many years. But these three buckets are quite common. And when it comes to tax warranties, typically it is 7 to 10 years. Basically means how long a taxman can come to you for assessment proceedings and open your book of accounts. So earlier there was a limitation that taxman can look into past 7 years books of accounts. So tax warranties are for example, about 7 years actually that point in time. So this is how warranties, etc., are dissected. Again, very important point within the indemnity is that, typically maybe you may have also come across documentations and saying that the promoters and the company shall jointly and severally indemnify, jointly and severally.
I have seen that. Yeah.
Yeah. That means investor has an option to either go against you or go against the company for that, indemnity payout. It is at their option. So there may be a scenario where company is cash rich and company can pay the indemnity amount, but still investor chooses to take indemnity amount from you.
ये किस लिए होता है
That
और जनरल केसेस में?
beg your pardon?
ये इन्वेस्टर किस लिए करता है इन जनरल केसेस में?
No, investor wants to keep its option open. Investor, you look at the logic from the investor side. Investor has given you money.
नो नो नो,
You are kind.
I'm asking कि अगर सपोज इन्वेस्टर इस कंपनी के इन्वेस्टर तो इसलिए कर रहा है कि ही वांट्स प्रोटेक्शन ऑफ हिज मनी, राइट, कि वेदर इट्स यू और द कंपनी, बट if the company is cash rich and still the investor is chasing you, is that mean that कि investor के साथ you have relation अच्छे नहीं है, he is just chasing you?
Possible, possible, absolutely possible. Possible that could be one of the reasons. That could be one of the reasons. And investors can also argue, saying that if I'm taking money from the company, some portion of money is my shareholding.
Yes,
Right?
yes.
Investors can also argue that. You see, they can argue. Look, a lot of people can argue a lot of things and say, if I take indemnity from the company, some portion, if company pays me X amount, that X amount could have been used for the purpose of reinvestment in the company, and that could have fetched more revenues from the company. People, you see, can argue lot more things, but it is always advisable for the founders to pitch these points to the investor, saying that, look, we don't deny indemnity liability because we are the ones who are giving you reps and warranties. We are not running away, but let us have a waterfall wherein you go to the company first, and the company is not able to indemnify you fully. For the balance portion, you can come to me.
Yes, that's reasonable.
That is called waterfall
Hmm. Hmm.
in indemnity jargon. Okay, instead of joint and several. Okay, another important aspect of indemnity is, again, depends on the promoters actually, how long they can sustain these points, etc. Of course, they legal advisors also, that it is also important that indemnity event, if at all there is an indemnity event, that should be determined by court of competent jurisdiction. So tomorrow there should not be any notice, XYZ notice from investor, saying that, oh, there is a breach of this warranty and I have suffered an XYZ amount. That XYZ amount is a unilateral amount, right? There is no
Hmm.
basis for that. You see, at times what happens, there may be certain breach of warranties, but there is no loss to anybody because of those breach of
Yes,
warranties,
yes.
right? you know and then the investor will say, okay, there's a there's loss of reputation, we interested you, etc. This happened, we have put in money. If we had put in money in some else business, we would have got this much of rate of return at this point in time, etc. You see, so it is also important that, if there is an indemnity claim, both the parties should come together and discuss. I'm telling you the middle ground here. Both the parties should come together and discuss, have a discussion in good faith. And then if either of the party, if promoters do not agree with the indemnity claim or the amount in the indemnity claim, then they have a right to invoke a dispute resolution provision
Hmm.
in the transaction document, which is arbitration. And once the arbitration has adjudged, given an award against the promoter, saying that you indemnify the investor, then you make investment. Then you make indemnity. So the difference between this scenario and the first scenario is that, if there was no good faith discussion or determination by arbitration, the moment investor will give you an indemnity notice, within 10 to 15 days you have to give an indemnity amount, right? Even if you don't agree. So you have been out of pocket from the day one, while you have disputed it also. Okay, and after 6 months or 1 year down the line, the arbitrator comes and says, you are not required to indemnify the investor. Then you take your money back. First you had got out of pocket, then you got in pocket after 1 year. But the middle ground is, both the parties discussed. If the promoters do not agree, you invoke arbitration, and then you make the payment after arbitration. Actually, this is, investors put all the points we are discussing. Investors push back on these points a lot.
Yeah,
You see,
gotcha.
investor pushback, because at times क्या होता है, for example, in especially in funds, etc. If they have been doing one kind of a deal in a particular one way, they want to repeat that documentation and those permutation combination again and again.
Hmm.
because because there may be scenario, they may think, okay, the other promoters have given me all the right, this guy is pushing me back on these,
Hmm.
right?
Hmm. Hmm.
So my earlier documentation, this documentation will be different,
Hmm.
right? So what if my investment committee asks me this question?
Yes. That.
But you see, every transaction is a bespoke transaction. Every investor has done deal in the same segment with different rights, obligation framework actually. You see, so it is up to us as founders council and the founders also, on important commercial points, to lay our points on the table, we should know, as we discussed, are must to have, good to have very important, because this also sends a signal to the other side that these guys are serious.
Hmm.
They are doing their stuff. They want a fair play. They want to understand. They are asking us questions. Okay, they are asking us right questions. So this also sends a good, good indication to the other side. If you're good at this, you're good at running, you may most probably you're good at running your business also, because you are everything you're looking with, sharp bent of mind and keen eyes, etc. So this is also actually a good indicator
Yes,
that
that
way.
means you understand the business
That means you understand the business, you have skin in the game
and
actually.
you're planning for long term as well.
Long term as well. So just an indication, but these are good
Yeah.
things actually. If somebody does it,
One thing
you see.
also जो कि अभी recently I have seen across very often.
हाँ, हम्म,
तो होता क्या है कि startups they want to raise funds. They don't found any supposedly like an Indian investor to put in the money. They raised from an international investor who says कि bro incorporate the company in US instead of India. And founders don't know about कि भाई legal conditions क्या रहेगा क्या नहीं. They go to a simple website जो उनको प्रोवाइड कर देती है कि गेट द कंपनी रजिस्टर्ड एंड स्टार्टेड एट XYZ अमाउंट ऑफ डॉलर्स. और वो इन्वेस्टर कह रहा है कि हाँ उतना पैसा मैं दे दूंगा सेटअप के लिए. They set up over there, they start the operations over there, and they begin with the rich. So, what is your advice in such cases? The founders who should they shift the residency of the company, or I can say registered office of the company, in that simple manner, or what should be the procedure if even if they are doing so, or would they you not recommend or so like? क्या रहेगा?
Look, residency is all play of available resources,
Hmm.
and resources in all terms. For example, you are an Indian entrepreneur,
Hmm.
and you have two options to set up your software company, either in Bangalore or in Jaipur.
Hmm.
What will you prefer? You will prefer Bangalore,
Yes.
because Bangalore is a software hub, IT hub, for example. You will easily have access to
Hmm.
relevant employees or relevant service providers in Bangalore, because that city is IT hub, right?
Hmm.
Easier access to capital also,
Hmm.
because most of the startups and especially IT startups are in Bangalore,
Yes.
etc. So when you see residency, you see all those permutation combinations. So what happened, a lot of Indian promoters started incorporating their parent companies abroad, was for the purposes of the other side of resources, basically raising capital.
Hmm.
Because, for example, you're incorporating your company in USA while the subsidiary remains in India, main business is in India. And there are many examples of it.
Hmm.
We have done several deals wherein the main parent company was outside of India, but operating entity was in India.
Yes.
Basically, all the income accrued to the holding company, basically. So that helped them to raise capital
Hmm.
from bulge bracket firms in, let's say, in US or European Union countries, actually.
Hmm.
But I tell you that trend is changing. So you must have heard about flipping of destinations or redomiciling of companies, like for example Udan, Flipkart, Meesho,
Hmm.
etc. All these companies are redomiciling to India, because India is providing them with all kind of resources, right, from employee resources to the service resources to the other resources to the capital raise resources, right? More the amount of FDIs we are having, more the trust, it means investors are putting more trust in India, right?
Hmm.
If there was no trust in India, there would not have been a spike in FDI year after year.
Hmm.
FDI is increasing in India year after year, and that is where you see all these companies redomiciling back to India and paying hefty tax also. That point in time, somewhere I was reading this Udan, I think PhonePe is part of, I think, a Flipkart entity, right? It ended up paying around 930 million USD something. I'm not exactly sure of that figure, but some very hefty amount of, in millions, in United States dollars, right? They did it. They wanted to domicile back to India, and same is the case with other companies also, right? So domiciling is play of excess of capital and access to the resources. That is how we see, and that is why we see a lot of companies want to come back to India. So earlier you had a lot of companies going to, if you see a lot of Indian fintech players, a lot of Indian NBFC players, their parent companies are in Singapore. Many of them, many of them.
That's true. Even I see similar shift with the funds as well, where funds are also shifting out outside India. setting up their family offices for conglomerates. Do you suggest the same thing? It's all about the resources that are there.
No, so what happens? You see, when you see this from the perspective of investor, definitely resources are important. Okay, but so the business of a fund or an investor is to invest. He doesn't require engineering resources, right, or medical resources, right? But a company which is into that field will require these resources, right? So there the play is, how much is the tax benefit, for example, I'm getting. That is why we've had prior to 2016, before the DTA got changed a lot with many companies. We had favorable terms with most of the countries, including Mauritius. We had highest foreign direct investment from Mauritius, right? Even today I was reading some data for this financial year. Singapore was the best FDI investment destination for India, followed by Mauritius, Japan, and many other companies. So from their perspective, whatever relaxations they are getting, tax benefit they are getting, that becomes important, because all these Cyprus, Mauritius, etc., those are tax havens. You see, for example, in Mauritius, you can incorporate a company within 12 hours to 13 hours.
Okay.
Yeah, within a day, definitely within a day. In UK, you can incorporate a company in a day. So
That,
I was once dealing with, couple of years back, dealing with one client. Okay,
hmm.
they advising them on entry strategies. To start with, they wanted to incorporate a company in India. It took them 1 month to incorporate a company in India, because all the documents, foreign documents, etc.,
Hmm.
have to be consularized, apostilled, notarized in the Indian embassy of that company. It has to come here, submitted with a registrar. It takes time, right?
So,
And that
don't
was,
you think
the client.
for them a better procedure would be to have a subsidiary company and just get as that as a parent company?
Depends.
Okay.
Depends. Depends, because the because that company was already doing very well in EU countries, including UK, for example, and wanted to enter India. So India was a first time market for them, and this happens with a lot of companies that are already in, for example, UAE and Japan. They want to enter India. Okay, so client was asking us, I can incorporate company in 24 hours in London. Why is it taking 30 days time? It takes time here, because you see, in India, capital flow, even the inflow is regulated. You see, from the economy perspective. So there is no kind of hawala transaction or any money that comes into India and company gets incorporated. There is routing of fund. It doesn't happen that easily, as
Yeah.
opposed to certain countries and tax havens.
Yeah.
And that is why you can incorporate a company within 24 hours in some jurisdictions, right?
Yes.
But every country has their own objectives actually to deal
Hmm.
with.
100%. And since we are talking about the funds aspects of the right things, right? So can you tell me about a bit how the fund in India is formed, like a VC fund, typical VC fund under Cat 1, Cat 2, Cat 3 categories, considering it like supposedly a Cat 1 fund, a VC fund, how it is formed, what are the legal structure of it is, and because it's a very lengthy process. Whenever I talk with people who want to start their fund, they say it's a very lengthy process. एक साल तो कहाँ जाएगा पता नहीं लगेगा. Approvals and all of that things.
It's a lengthy process. So I tell you, the laws governing setting up of funds in India, investment fund in India, is alternative investment fund regulations. These regulations came into picture in 2012. Okay, now these regulations have several categories of funds which can be incorporated depending on the objective of the fund. For example, there is a category 1 fund. Okay, typically all the venture capital funds are category 1 fund. There's a category 2 fund. I have seen venture debt funds are category 2 funds, for example, because that is their investment strategy objective. Category 3 funds are funds which have flexible and complicated investment strategy and invest into derivatives, for example,
Kind of
hedge
mutual
funds,
fund.
etc. Hedge funds, etc. All of them. The mutual funds regulations are separate regulations. AIF regulations are separate regulations. Okay, AIF regulation, basically you are pooling in capital from investors for the purposes of investing into another entities and giving benefits to the investor, and that is what a fund does. Earlier, prior to AIF regulation, we had venture capital fund regulations, etc., separate, but now we have AIF regulation which takes care of all kinds of private equity funds to whoever want to establish it. A fund can be set up in various ways as per the regulations. It can be set up as a company, it can be set up as a LLP, or it can be set up as a trust. Most, yeah, most of the funds you will also see if you go to SEBI's website and see, based on my experiences also, I tell you, most of the funds in India are structured as a trust actually.
Hmm.
So the purpose, okay, are set up as a trust. Now, a trust is set up by the settlor, person who creates that trust. Okay, he appoints a trustee. Trustee is the person who manages that trust. Okay, the fund is a trust. Okay, and the fund will float several schemes and issue units, etc. Okay, although they invest in other companies, subscribe to their capital, etc. They will issue units to their investors actually. Okay, once this trust is formed, now the trustee appoints a person called investment manager to manage the fund. You see, you're managing the fund, administrative expensive, this is expensive, deciding on the new targets, new sectors, new startups, etc. based on the objective of your fund. So there is an investment management agreement to this. So first we have a trust deed, duly registered trust deed. Then we have investment management agreement, so that the investment manager can manage. And and then there is a person who is also called the sponsor. A sponsor is the person who is the main person who has set up the fund and who carries gives continued interest to the fund over a period of time. And then you want to take investment from various investors. And how do you do so? You do so by entering into contribution agreement to them. So you issue units to them, and units are classified based on the amounts and preferences, class A, class B, depending on what rights and privileges you want to give at different point in time in scheme you have. Okay, and then there is a private placement memorandum. That is another document which talks about objectives of the fund, main people of the fund, strategies of the fund, every disclosure, the format prescribed by SEBI. So you apply for registration of the fund along with the draft private placement, memorandum to the SEBI. SEBI evaluates it. You pay the amount, etc., registration amount, etc. SEBI gives you registration. Once you have registration in place, you can enter into all these contracts and take investments through contribution agreement from investors. Yes, it takes time. So SEBI has been typically, in our experience, have been taking around 8 to 10 weeks to clear an AIF registration. At times more also. At times more also. If there are questions and follow up correspondence, time increases actually. But 10 to 12 weeks, mota you can आप मान के चल सकते हो. Okay, this is what SEBI has been taking. Depends on your follow up also how you have been doing. So I agree. Managing a fund is not easy, right? Once you have started a fund, have different investments, managing those, you having LP advisory committee, all those resolutions. So it is a task actually.
Hmm.
For that way.
That's true. That's true. So basically, what I summed it up like on the notes. So it's like three.
There are many more. AIF regulations are very wide actually.
Yeah, yeah,
So, for example, category one, there are other conditions also. Category one funds have to invest 75% of their corpus in unlisted securities. Okay.
yes, yes, yes,
Okay, and the minimum funding, maximum funding, with the funding requirements also, they're 1 crore from one investor and
yes,
maximum
yes, yes.
1,000 investors. Angel funds is bit different.
Wait,
So all those permutation
that's-
combination also there. But what we have discussed is from a high level perspective, that
yeah,
this is the
for
permission.
just a bird eye view of the things.
Bird up.
In the bird eye view, we talk about three companies that are formed for a fund. That is a trust, that a sponsor, and the investment firm, right?
Investment management company.
Investment management firm.
Yeah, investment manager,
Yeah.
which manages the fund.
Yeah. Okay. Interesting. Interesting. And see, a lot of my friends want to set up funds and all of that part, right? So, what do you advise them in that manner? We talked about the startup things when, obviously, in setting up a fund, lawyer is the first thing that you go to and get the things done. But still, a lot of people are stuck who have been in process of setting up funds like more than a 1 year now, 1.5 year now. So, what do you think the major problem that arises in setting up a fund?
Look, setting up a fund, major, I will not say problem. The major indicator is what is your investment strategy. That is important actually.
Hmm.
That is important. So setting up a fund is different from setting up a startup company.
Yes.
Company you can set up, if you're an Indian promoter, all the documents are already there with you. You can set up a company, 10 days within the submission, getting name of the company, etc. But in case of fund, what happens? Firms are highly regulated because you require registration from SEBI. While giving registration, SEBI also consults another regulators also, and that is where SEBI also takes time actually. You see, especially if a foreign player is looking to set up a fund in India.
Yes, 100% agree. Agree.
So you have to see all the indicators. You have to see what is the net worth of those individuals who want to set up in India, whether they have existing investments. Okay, who are these people who are doing it?
Mm,
So I tell you, back there in 2007, for example, a lot of venture capital funds that point in time was set up through investors in Mauritius. Okay, so they will set up a company in Mauritius, apply for a VCF registration in India. So they were concerned by the RBI, who are these people? Because in
mm.
Mauritius, for example, I don't know now, but that point in time, you can incorporate a company with $1 paid up capital.
Okay.
Anybody can afford that $1 paid
Mm.
up capital. Even in India, there is no minimum paid up capital
Yes.
requirements. Not now, right? You can incorporate with 1 lakh, 50,000, 5,000, whatever you deem fit, right? So that is there. So that is why managing a fund, you have to have several internal stakeholders, right? From investment manager to the trustee to the settler to the sponsor to the contributors. You have to manage them, right? And then you have internal LP advisory committee, internal investment advisory committee. What is typically in their jargon is called as key investment team.
Mm.
Now, SEBI also prescribes that at least one of the members should be duly qualified. All the qualifications are there in the regulations and the circulars by SEBI, etc. So, fund space is a more regulated space as opposed to a startup kind of a scenario. Because if the startup is not a NBFC startup or not doing anything which is regulated by RBI or SEBI, you don't need to get registration certificate from anybody, right? You can get going right from day one you are formed, right? But that is not the case with funds actually.
I see it. I see it. That's absolutely right. Just one last thing that I want to know from you. This is like lot of questions that have been asked it around. So the last thing is how you realize that the lawyer that you're working with in a case is on your side, not on the other party side.
Look, a lawyer is always on the side of their client actually. Okay, now as we discussed, why I'm re-emphasizing on that point is that as long as you are representing your client, okay, and you are clear in must have and good to haves, you are sorted. If you do not know it, then there is a difficulty, because if you do not know, every good to have is a must to have for you, right? You're fighting for every good to have or even not so good to have points as must to have points. That will, something what is called reading the room, etc. That may not go down well with all the other stakeholders, right? So if you're negotiating very harshly and holding up the deal for a point which is not material, which can be traded for some other point, it doesn't go down well with all the stakeholders, right? Time efficiency is important, let me tell you this, right? Time efficiency does not mean closing the deal within 24 hours, right? But it means closing the deal within the reasonable time period so that all the parties are aware of what they are signing to. Because all these, you see, all the transaction documents are not for good days, they are for rainy days when you are in trouble.
Yes, yes.
The best transaction document is a document that doesn't open up. But tomorrow if it opens up, you have to see, did we raise this point?
Mm,
Okay, if we had raised this and won this point, it is already there in the document, you can say, right? So you are covered that point in time. So I tell you, I was the once negotiating one deal, and we had just completed that deal.
mm,
Okay, that person, very good company, was taking investment from one of the bulge bracket private equity investment firms in India.
mm.
And that private equity investment firm has investment in many Indian companies actually. Okay, so there was news in the news item in the paper one day once we had closed our deal. Just 10-15 days after that, that fund along with other fund who was the co-investor, they are having not so great relationship with the founder. Over a period of time, they terminated that founder from the employment agreement, gave the founder notice and terminated it. The employment agreement of that founder with that company, for that company, did not have, you know maybe they did not raise the point that there should not be no cause termination. Actually, you cannot terminate me without any cause, right? Maybe, I don't know. Okay, straight away our clients called us up. Okay, he had the same investor. He called us up. Okay, I've read this. So tell me, what is my employment agreement? We told our client this was the point we were fighting out for last 18 days.
Oh,
You
okay.
cannot be you cannot be terminated without cause. Tomorrow, investors cannot tell you, okay, take this 6 months notice, take this severance package, take this bonus, and get out of your own company. No, there has to be cause and established cause.
Hmm.
You see, some points are very important, and that's why I've said must to have and good to have. If you have this clarity, not everybody has this. This is all a pure play of your involvement over a period of time with different set of people and your experience at play. Because what happens, something which is must to have in a particular deal may not be must to have in another deal. Actually, may not be, because you also have to read the room, right? You have to close the deal. So whenever we as lawyers, we advise our clients, we have to wear two hats. Definitely a lawyer's hat, because we are qualified to do so, and also wearing the founder's hat. Dhanda chalana hai. Have that mentality. Act as a catalyst to the transaction. Don't stop the transaction, don't break the transaction, but come out with solutions which work equally for all the parties, which ensure fair play. And that is where representing a founder is not that easy, right? Founder trying to create a fair play for themselves in a transaction document is not easy. Actually,
That's true.
it requires effort.
That's
Creating a fair play for the investors is bit easy as compared to the founders, actually.
interesting. I'll ask you one more thing, right?
Yeah.
So this is like from a personal experience.
Yeah.
So I was involved with a deal somewhat around pre-series A, Series A, the banker, individual banker. So I and अपना deal आगे नहीं बढ़ा था because of one clause
Okay.
that was there. The thing was, the clause says कि whenever I introduce them to an investor, they have a reasonable time to tell whether they already know him or not. Like they can tell, if they knew the already an investor whom I am connecting them with, then there is no success fee or any charges applicable. But if they didn't, then there is a typical investment banking thing. But my thing was, hey, can you guys add like there should you should inform me such thing within like 6 hours, 2 hours, 5 hours, something like that. And from the legal aspects of the founders team, I didn't heard anything back on that thing again and again. So what do you think on this legal aspects?
No, tell me, just to understand it fully, you were acting as investment banker.
Yes.
You were introducing that startup to a prospective investor,
Yes.
and the framework had a clause that is that startup already knew that investor,
Hmm.
then you will not get success fee.
Yes.
This is absolutely off market, actually. Look,
Hmm.
knowing someone and getting a funding from that very person is totally different aspects,
Yes.
right? So I am a startup founder, you are a deal arranger, for example, an
Hmm.
investment banker in this case.
Hmm.
I know Mr. XYZ. I had met Mr. XYZ 1 year back, three, five, 7 times, right? But nothing materialized. But now you have introduced me, so your brand value is also at play, correct? Because what happens when an investment banker comes into picture, look, investment banker, for example, nowadays it is happening, but if you see a bigger investment banking firms, vendors to the board house, to the other firms, they don't operate at seed level, right, or
Yes.
pre-series A level. They operate at a larger level, because once they get engaged with a particular company, they prepare the case for that company.
Hmm.
They are giving you that exclusivity. They are working for you, right? Now, a normal effort to a XYZ person directly by the founder may not yield result, but an aligned approach. You have worked for the company, created a case for the company, right from the business plan to everything you have created, and you have approached the same XYZ person with that documentation. That is a higher chances of working. So
Yes.
I cannot say that since I had met him, I'm generally telling you, I don't know what was there. Okay? But
100%.
it looks off market to say, actually say that I knew I have already met him.
Mm.
But he's not investing on my previous meetings, right? He's regenerating the discussion because there is someone who is, mediating between us, acting as a,
Yeah,
investment banker,
that,
right?
that sounds, yeah,
And
that,
that is why you see all the companies, all top companies,
mm,
you see all listed companies, also bigger companies, they invite bidding process. They instruct one of the topmost investment bankers saying, look, I want to sell off my stake.
mm.
Why don't you, help me in preparing everything and look for investors and buyers in this case? And that firm is doing that, right? And doing that for several. We have worked with a lot of investment banking firms in a bidding kind of a scenario where investment banking firm had, worked with the company, created a pool of good, high quality 10 to 12 investors and were managing all of them, right? So why the company is going to the investment banker in this scenario? Why the company is not doing it directly? Why it is paying crores of fees to the investment banker? If they could have done it directly without investing much time, they would have already done it directly.
Then I would say I was fortunate enough that I had such kind of, or you can guidance. So I dropped that deal at back then as well.
Okay.
Yeah, so similar kind of guidance in that manner. So yeah, that's absolutely true. That's the same what I think. Just knowing a person doesn't mean that it's the fundraise kind of a thing.
Right.
It's the relation that you hold. It's the business that you have built. It's a lot of things, as you rightly said. Goodwill.
Lot of things. How do you prepare your case? How do you showcase your number? You
Yes.
see, how do you sell your basically sell your aspirations? All these are at play. Ultimately, you are selling a product for investment, right? In a way,
Yeah.
that is how it is, right? You are a salesperson, right?
Yes. 100%. So it was the last question. So it was like wonderful hosting you. To me, I have prepared out notes. It was great learning opportunity for the startups as well as the VC investment sides. And even I got a free advice which I hadn't paid for the last question. But
That's all right. That's absolutely all right.
yeah,
Same here, Himanshu. Wonderful interacting with you. You're doing a lot of good work, right? You are trying to reach out to some good people in the market, and that is what we need actually. So we are part of a generation very much, which was moving from $1 trillion economy to a $3 to $4 trillion economy. New generation is moving from $4 trillion economy to $10 trillion economy.
yeah,
So everything would be very much changed. You will see in next 10 years. Indian economy is poised for growth. We need excellent service professionals. There'll be dearth of excellent service professionals. I'm telling you, we do not have that resources, and we do not scale up if we have those resources. Right? How do our companies and startups do whatever they scale up? They need professionals, right? How do our regulators run?
yeah.
Regulators need good professionals, right?
Yes,
Otherwise, regulators will create regulatory unnecessary regulatory hurdles. Their people will not understand how the business is going, right?
that's the thing.
So we need a lot of good resources. We need a lot of good resources in every aspect. Then only we can move from a $3 trillion economy to a $10 billion economy. The way we are poised, actually.
That's true. That's true. That's 100% true. So yeah, here we will mark the end of this conversation.
Thank you so much for having me. Wonderful interacting with you. Cheers.